Hi, my name is Sarah Batson, and I am an attorney with Maynard Nexon's Employment and Labor Law Practice Group. As an attorney, I work closely with businesses in managing employment-related risk and represent them in employment-related litigation. Today, I'm going to cover a brief update on recent developments at the National Labor Relations Board and explain how they may impact employers. First, what is the National Labor Relations Board, or NLRB? The NLRB is the federal government agency that enforces the National Labor Relations Act. The act was passed in 1935 to protect workers' rights during the Great Depression, and it established the NLRB. The NLRB provides certain rights to employees, including the rights to form, join, and assist unions, bargain collectively through representatives of their choosing, engage in other protected concerted activities for the purpose of collective bargaining or other mutual aid or protection, for example, the auto worker and actor strikes going on now, and refrain from any or all of the above. The NLRA applies to most private sector employers, but it does not apply to supervisory or managerial employees. Today, I will specifically cover the NLRB's recent guidance on employers' obligations to protect employee rights to engage in protected concerted activity. In its August 2023 Stericycle decision, the NLRB announced a new rule for assessing workplace policies for legality under the NLRA. Under Section 7 of the NLRA, a policy cannot interfere with an employee's ability to exercise protected concerted activities. Examples of protected concerted activity include discussing wages, hours, or working conditions, and criticizing management. Under the Stericycle decision, even if a policy does not explicitly violate the NLRA, it still violates the NLRA if employees would reasonably construe the language to prohibit Section 7 activity, or the rule was created in response to union activity, or the rule has been applied to restrict the exercise of Section 7 rights. As opposed to the balancing test of the prior board, the NLRB will now analyze these workplace rules from the perspective of an employee who is economically dependent on the employer. Under this approach, the question is whether an employee could reasonably interpret the rule to prohibit certain protected concerted activity. If so, the rule has a tendency to chill employees from exercising their Section 7 rights and discussing their wages, hours, or other terms of employment, and that makes the rule presumptively unlawful. In other words, if an employee may be afraid that they would be disciplined for violating a company rule, even if the activity is within their rights, that rule could unlawfully chill protected concerted activity. So what does an employer do if a workplace rule is considered presumptively unlawful? The employer would work to rebut the presumption. According to the NLRB on August 2, 2023, an employer can rebut the presumption that a rule is unlawful by proving that it advances legitimate and substantial business interests that cannot be achieved by a more narrowly tailored rule. Finally, in the wake of this new decision, employers are encouraged to review their policies and work rules with counsel. In evaluating these policies, employers may want to prioritize the following as they work through their list of policies: workplace civility rules, non-disparagement policies, policies prohibiting video and audio recording by employees, restrictions on employee use of social media, policies requiring confidentiality of investigations and complaints, media communication policies, and any policies addressing employee interactions with another employee and management. Employers should review policies that could implicate protected concerted activity to articulate legitimate business interests that the policy is intended to address, analyze industry standards, consider any less restrictive alternatives, and provide language to expressly protect workers' Section 7 rights. The Maynard Nexon team is always glad to assist employers in reviewing workplace policies in light of these regulatory changes. Please let us know if we can assist.